So first and foremost, hi, my name is Elizabeth Parker. I'm the senior civil appellate attorney at the Speaker Law Firm. The law firm as a whole is a boutique appellate firm, and we also do trial court consultation and trial court support. We have several attorneys who handle family law type issues. I do not. I come from a commercial litigation background and employment litigation, and so I have that as my background, and those are the types of appellate matters that I focus on. I also handle probate appeals. With me today is Ryan Plecha, who is at Baltzell. And Ryan, I'll let you introduce yourself to the crowd.
Thank you so much, and thank you for having me. Welcome to everyone who's joined. As Liz said, my name is Ryan Plecha. I'm an attorney at Baltzell in the litigation group. My practice is primarily in business and commercial litigation, pretty much exclusively. So I've lived the arbitration for probably the last 5 years as it became more popular. So happy to share some tips and tricks along the way and join Liz in doing this Arbitration 101 today.
Right. Thanks, Ryan. So I guess the fundamental basis, what is arbitration and how is it different from mediation? Sometimes people will ask that question, is it the same as mediation? And it's very different. Ryan, do you want to talk about that?
Yeah, thank you. So that's one of the primary questions I get a lot from clients, especially who don't have the experience of litigation, in their belt, is this binding? So usually that's the cue to go over the difference between mediation and arbitration. Arbitration is generally binding, where a party or the parties agree to submit their dispute to a private individual as opposed to the court. So you'll have a practicing attorney, a retired judge who will act as the arbitrator, who will hear the case, hear the evidence, and ultimately enter an award. Whereas mediation is more of a negotiation process where the neutral is used kind of as a referee or someone that goes back and forth in a shuttle diplomacy situation to try and find a resolution that both parties will agree to. They might not like, but ultimately are able to agree to live with so that the case is resolved and final. Whereas arbitration is actually litigation in a private setting as opposed to in the courts.
And I know from our experience, both with the commercial litigation background, you generally see arbitration agreements in the context of contracts for services, contracts for goods, where the parties have, at the time of making their contractual relationship, have incorporated an arbitration clause, so that before any dispute has ever arisen, they've already agreed that if one does, they'll go to arbitration. But there's nothing that says parties can't agree to arbitration after a dispute arises, of course. They certainly can do that. There are several statutes that actually address arbitration and form sort of a legal parameters for arbitration. The first is the one that most people would be familiar with is the Michigan Uniform Arbitration Act. That's at MCL 691.1681 at SEC. Ryan, that's the one you're the most familiar with, isn't it?
Yeah, so the Michigan Uniform Arbitration Act generally is the rules to the game as far as arbitration in Michigan. It sets forth all of the rules and the procedures for what is necessary to create a binding agreement to arbitrate, the procedure for invoking and enforcing the arbitration provision, how the arbitrator is selected, the obligations of the arbitrator, and what their authority is and what limitations there are. It also sets forth how arbitration award can be confirmed, vacated, modified, or corrected. It also sets forth what can be appealed from a court order to a higher court, which is more of your realm, Liz, in the arbitration appellate situations.
Okay. And there's also, on the federal side, we have the Federal Arbitration Act that's found at 9 U.S.C. Section 1. That generally broadly applies to contracts involving interstate commerce, and it's been interpreted by the Supreme Court to actually preempt state laws that would otherwise invalidate arbitration agreements. There are some differences, certainly, between the Michigan statute, which is pretty detailed in terms of what your rights are and how things like discovery and the proceeds as opposed to the Federal Arbitration Act. And we'll discuss some of those differences a little bit later, but people should just be aware of the fact that there is a separate federal statute that may be called into play. Thirdly, there is Michigan has the Domestic Relations Arbitration Act. That's at MCL 600.5070. I want to mention it, but that's about all I'm going to do about it. I want people to be aware that it exists, but it's well beyond the scope of this webinar or my experience or Ryan's experience. If you are someone dealing with a family law arbitration issue, we have people at our firm, and I'm sure at Butzel as well, who are well experienced at that. They would not be Ryan or I. So we want to put it out there that it exists, and then now we're never going to talk about it again. Family law scares me. Now, lastly, and I think it's worth mentioning, common law arbitration. Basically, common law arbitration, and it's perhaps, I think it's a little bit in flux, but ordinarily your arbitration agreement will refer to either the Michigan Uniform Arbitration Act, or it will say arbitration under the law of the state of Michigan, or it may invoke the Federal Arbitration Act. If it doesn't actually refer to any statute at all, then it's commonly considered common law arbitration. And that has a notable distinction in as much as the right to revoke the arbitration agreement can be exercised anytime before an award is rendered. Now, it doesn't mean that just because your arbitration agreement doesn't specifically call out one of the statutory provisions that it's revocable. What it means is if it doesn't include the statutory certain statutory protections that are included in either the FAA or the Michigan Act, such as if it doesn't allow for a circuit court to enter judgment on the award, then it could be construed as common law arbitration as opposed to statutory arbitration. There's a case in Michigan I just want to point out, Wald Architects and Engineers versus Strat, and the site on that is 474 Mich 223. It's a 2006 case, and it was actually decided under the former Michigan Arbitration Act. And in that case, because the arbitration agreement didn't specifically provide that a circuit court could enter judgment on the award, it was considered not to be statutory arbitration and only common law arbitration. That question hasn't come up in the context of the new Michigan Uniform Arbitration Act. And so it'd be interesting to see if that question were to come up in the light of that statute, whether that outcome would change. But again, be aware that there is still, at least as it stands right now, a common law arbitration element out there.
Yeah, not that everyone doesn't want to be the test case in the appellate courts with you in your office, Liz, but this brings to the point that arbitration is definitely a creature of contract. So I strongly advise that you have your clients check their arbitration provisions, make sure it's doing what they think it's doing, and to revise those to make sure that if you want to be in a particular arbitration forum, that your contract says that, and that it doesn't just assume that it's always been there, so I'm sure it's fine. Having that review is an essential element to not having surprises when your client thinks they're doing arbitration under the Michigan Act and there's a missing element. So it becomes common law and the other party says, I don't want to arbitrate. I want to file this in court. So better to know that in the beginning and to advise your clients on how to revise those agreements than to wait and see what happens, when it gets before the court.
Definitely. And I think that that's really important advice to, as a takeaway. If you are someone who is drafting these agreements, making sure that you're incorporating the Michigan Act, if that's what your intention is, or the FAA, if that's what your intention is, and specifically calling it out as the statutory provision that you want your agreement to be governed by.
And so this brings us to challenges to arbitration clauses. Is you have your agreement, it says what it says, but you decide you don't want to go to arbitration despite your agreement to do so. So are there any ways to challenge arbitration agreements, Liz?
There are. As a threshold issue under the Michigan Uniform Arbitration Act, the court actually plays a role in determining whether there's a facial agreement to arbitrate that exists between the party, and then whether the particular issue, the dispute that's arisen between the parties, is subject to that agreement. But in terms of all other issues, including some of the common avoidance doctrines that apply to contracts, all of those other issues are actually decided by the arbitrator. So that includes whether a condition precedent to arbitrability, which is a tough word to say for me for some reason, if all those conditions have been fulfilled, and then also whether that particular agreement that is facially on the party's written contract is actually valid. Similarly, if you're under common law arbitration, MCR 3.602 ties in to those types of scenarios, and that provides for court intervention to enforce arbitration agreements, and it also provides a procedure to confirm the award and to seek appellate review. It's again, by its language, it says it does not apply if the Michigan Uniform Arbitration Act applies. So it's where you go if you find yourself in that common law arbitration avenue. Under the Federal Arbitration Act, it's very similar to the Michigan Act in that the court will generally just decide whether an arbitration agreement is enforceable. But there's an important exception. Under the FAA, the court will also decide those sort of gateway questions, the avoidance doctrines that we mentioned earlier about the validity of an arbitration agreement. So whereas at the state level, the court will simply look at it and say, yes, there's an arbitration agreement here. And one party says, I signed it under duress, and the court in Michigan will say, go tell your arbitrator to examine that issue. Doesn't mean it can't be examined again on review, appellate review, but that issue will be first deferred to the arbitrator. Under the Federal Arbitration Act, the court will actually address those fundamental contract issues. There is, however, a key exception to that. If the parties' agreement clearly and unmistakably, and that clearly and unmistakably language comes from a case, if they have agreed that the arbitrator should decide questions of arbitrability and enforceability, then again, the court will defer that to the arbitrator. And that typically happens when the parties incorporate certain rules that give arbitrators authority over those questions. For example, the American Arbitration Association, they have different rules that govern different types of disagreements and different types of issues. And in those rules, they oftentimes have specific provisions that delegate that responsibility to the arbitrator. I wanted to drop a quick case site for anybody interested in looking at that issue more closely. Rent-A-Center West versus Jackson, 561 US 63. It's a 2010 case from the Supreme Court. And that was one, again, where the Supreme Court emphasized that there's a presumption that courts decide arbitrability questions unless there's clear evidence that the parties intended otherwise. So are there any statutory exemptions to arbitration agreements?
Yeah, so there are some statutes that specifically say the Michigan Arbitration Act doesn't apply. For example, if the agreement to arbitrate is between members of a voluntary organization and the arbitration is to be administered internally among that organization, those would be exempt from the Michigan Uniform Arbitration Act. And that site is MCL 691.16832. They also do not apply to sexual assault cases. In Michigan, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021 was signed into law, and that prevents pre-dispute arbitration agreements related to sexual assault or sexual harassment claims, primarily in the workplace. The FAA also excludes transportation workers who are actively engaged in interstate transportation. And that site is 9 USC Section 1. There's also a case that discusses that, Circuit City Stores, Inc. versus Adams 532 US 105, and that's a 2001 case. Not overly interesting or complex, but those are some exemptions out there. There's also been a recent trend for some of the states to take a harder look at consumer agreements to arbitrate. You know, essentially you buy a piece of software or you're on a website and you click the I agree because you just want to buy or use the product that you've purchased or want to purchase. And some of those click provisions that contain the arbitration agreements have been challenged. Not surprisingly, California has a Senate Bill 940 that became effective in 2025 that prohibits a contract for the sale or lease of goods or services, family household equipment, otherwise that would be subject to arbitration. It says we're not going to compel these parties to arbitrate because it wouldn't be fair to do so. So there's other states that are probably in the process of doing that because there's such an overreach by some of these companies who have these click-through arbitration provisions that people didn't know, A, that they were entering an agreement to arbitrate, and B, even what that meant. So some states are taking a closer look at that, specifically in the consumer context.
Yeah, and it's interesting to see how broadly some companies are attempting to enforce those click-through agreements and you know, things buried into terms of service. I know one case that you and I have just discussed casually because it was somewhat interesting to us, involved Disney Plus subscription. And did you want to discuss that a little bit?
Yeah, so there was a case, this was going back, I think, to 2024. There was a couple who went to dinner at a restaurant that was on a Disney property, and there was some food allergies involved. Unfortunately, the wife had some allergens in her system. She went into anaphylactic shock and passed away. There was a wrongful death suit filed in Florida. And Disney said, no, wait, you can't bring that in court. You signed up for Disney Plus, and Disney Plus had an arbitration agreement in it, and it also incorporated all of the Disney terms and services, which also included an arbitration provision. So Disney kind of went out of its way to enforce an arbitration provision in a wrongful death case that had nothing to do with Disney Plus, but because it was a parent or a related entity, they tried to use that as a sword to try and have that case dismissed. Disney got a lot of heat for that in the media, and especially in the legal community. So they ultimately ended up withdrawing their motion to dismiss based on arbitration grounds. But there were also some interesting takeaways from that. There were inconsistencies between the Disney Plus arbitration terms and services and the Disney parent entities terms and services. So there was an ambiguity argument as to the party didn't know even what they were agreeing to, so it shouldn't be enforced. But I think this was really an issue that was kind of ruled on by the court of public opinion. Disney made a calculated decision to withdraw that request and to let the case proceed in Florida Circuit Court.
Yeah, that would have been pretty shocking to find out that your Netflix and your Disney Plus subscriptions are suddenly binding you to arbitration when you're having what you believe to be completely unrelated interactions with parent and affiliate companies. So it would have been interesting to see how the court would have ruled, but I think Disney Plus, like you said, they really felt that the PR battle was lost, even if they won. And I know that there is a Ninth Circuit opinion that sort of came to the conclusion that it would be absurd to make customers arbitrate all disputes with any corporate entity that happened to be acquired by, it was a AT&T. That's a Revich versus DirecTV. I don't have the actual opinion site, but it was out of the Ninth Circuit. So if anyone's dealing with any of those types of, overly broad applications, you might want to look at that case for some guidance.
And there was a Fourth Circuit case that kind of ruled the opposite, that did enforce the subsidiary successor with the ability to enforce the arbitration provision. So it also really comes down to, kind of like I addressed before, if Disney's terms were all the same across the board, they would have had a legally stronger argument. I don't think it would have changed the court of public opinion, but just making sure your arbitration provisions across, affiliated or related entities are consistent, that would make it more likely that those would be enforced.
No, interesting. It'll be interesting to see if maybe the conflict kind of between the Fourth and the Ninth makes its way up to the Supremes, and see, if they chime in on any type of thoughts on that.
I mean, I don't know what your opinion is, Liz, but I think this is probably more of a legislative issue, like we saw California kind of taking their crack at what is enforceable and what is not enforceable in the consumer context. But I kind of see it playing out more there than in the courts.
Yeah, I mean, and I think you're right. I think that's, was the motivation behind California, was seeing, how many agreements, I mean, almost anything that you click anymore has, pages and pages of terms and conditions that, let's be real. I mean, we're attorneys and we don't even read them. So I feel pretty confident that nobody else is. So yeah, definitely that is the impetus behind a lot of that. So let's move to procedure. Let's assume that the court has enforced your arbitration agreement, or there's no dispute. Everybody says, yeah, we agreed to arbitration. What does it look like procedurally? Under the Michigan Act, it permits the arbitrator to provide for ordinary civil discovery and litigation procedures, such as depositions, evidence production, all the things you would kind of normally see in circuit court litigation or district court litigation to a lesser extent. But the Act gives arbitrators very broad discretion to tailor discovery to the specific circumstances of the case. Looking at fairness, efficiency, cost effectiveness. So, it's not going to be the same broad discovery necessarily. You're going to have to probably, offer to your arbitrator, an explanation of why you need a certain deposition or why you need certain documents produced or interrogatories answered. But the Act does certainly provide the arbitrator with the authority to order that. And the Act also provides similar enforcement mechanisms as we have in court proceedings. Ryan, is the FAA any different?
It is actually. Thank you for the softball. Yeah, so the FAA is actually a little bit more restrictive in what it does allow for discovery, especially pre-hearing discovery. Under the FAA, the only obligatory discovery is that the arbitrator can subpoena witnesses or documents to appear at the arbitration hearing, not necessarily pre-hearing discovery. The parties obviously can always agree to other discovery mechanisms outside of what is available under the FAA or required by the FAA, but that is something that does surprise people quite often. There's actually been some interesting theories and ways to get around this by requesting the arbitrator to have a hearing solely for the purpose of having documents produced at that hearing, but not having it be the final merits hearing, which gets into questions of whether that's compliant with the intent of the act or going around it. But I mean, again, those things happen until they get tested and ultimately resolved in the courts, which you're in arbitration, your whole point was to avoid the court system. So it's an interesting chicken and the egg type of dynamic with some of those issues.
Yeah, definitely. Now, if your arbitration agreement actually refers to, for example, the AAA or JAMS procedures, then those entities have their own rules, which are dependent on the nature of the dispute. They have, at least with regard to AAA, which I'm much more familiar with, consumer, commercial, construction. They also have expedited proceedings for lower value matters. And all of those rules, depending which one you're falling under, have in them very specific processes and procedures for discovery. And so typically, you would refer to those rules first and then raise issues with your arbitrator. Um, and I know, Ryan and you and I both have experience litigating under those AAA procedures. What's your experience like dealing with an arbitrator under those AAA procedures and in the
Yeah.
discovery context and even more broadly?
Yeah, I think it's definitely kind of the umbrella of AAA provides the general outline of what can and can't be done. But in almost every case, whether it's a three-person panel or a single arbitrator, they will tell you what the rules are going to be because they each have their own preferences and what's worked for them over the years and what hasn't. So it is definitely driven by, at least in the case of AAA and probably JAMS as well, you'll have a meeting with the arbitrator as to what the schedule looks like, what are the needs of the case, and there'll be a scheduling order that sets forth the discovery, whether interrogatories will even be allowed, the amount of depositions. In the most recent case that I am dealing with, we have what's called a Redfern schedule, which kind of goes to the meaning of that you said, Liz. It's kind of a more restrictive discovery. And a Redfern schedule is basically a spreadsheet that says this is the document or the type of documents that I'm requesting, and this is why I need them, or this is why they're relevant. The party you're sending that to can object or agree, and then that is then sent to the arbitrator to make decisions on each of those items. So they have everything kind of set forth in this schedule of what's the document, why do you say you need it, why does the other party object, and here's my ruling. So it definitely is a more streamlined approach and kind of gets some of those preliminary issues out of the way, and you're not asking for things that you don't have a basis for.
Yeah, no, that's interesting. An interesting procedure. I know with some of the arbitrations that I had in my prior to appellate life, um, they were just, yeah, they were all over the board. I mean, I recall one arbitrator who was a Michigan-based litigator and was very comfortable and accustomed to very broad discovery, and was just like, they asked for it, give it to them, don't bother me with your discovery motions and your objections. And then I've had the other end of the spectrum where it's like pulling teeth from my arbitrator to get something. I'm not even arguing with the other side now. I'm trying to get my arbitrator to give me the consent to ask for things. So um it's one interesting thing, about litigating under the AAA procedures and the level of discretion that's more broadly afforded to arbitrators. So let's assume that you have your award. Um, Moving on past procedure, you've won or you've lost. What are your options? What do you do at that point? Um,
Call Liz.
You can do that, and I will certainly be glad to help you. Short of that, it kind of depends again how you got to arbitration. So if you're under the Michigan Uniform Arbitration Act, um, what are your options there to move forward with your award?
So under the Michigan Act, you have to first decide, has an action been filed or not? If there's a pending action that was ultimately quote unquote removed uh, to arbitration, you have to file a motion within 21 days of receiving the award for the court to essentially convert, using that term loosely, the award into a judgment. Whereas if there's no action filed, you actually have to file an action with the court within 90 days of receiving the award. So depending on what the procedural posture of the case is when you entered arbitration, that decides the procedure and timelines on when you need to get that reduced to a judgment. But there are things that the court can do to modify. If there's a clear math error, the courts can correct that from the award to the judgment. If there's any other clear, misnomers or typographical errors that are clear on their face, the court can make those corrections from the award to the ultimate judgment that's entered by the court. Or if there's some other award that is imperfect in a matter of form not affecting the merits of the decision, the court can address those as well. But it is really kind of limited to more almost administrative or typographical or math errors that a court can correct these. So Liz, is there anything under the MUAA that the court can do to vacate or otherwise throw out an award?
There is. You can ask the court to vacate the award entirely on grounds such as corruption, fraud, evident partiality, or misconduct by the arbitrator. The court can also vacate an award if the arbitrator exceeded the arbitrator's powers, or if there was no agreement to arbitrate. And this goes back again to, that initial, circuit court has the power to make that initial determination whether there's an agreement to arbitrate. Or if the arbitration was conducted without proper notice of its initiation. And so that gets into some sort of, weird parameters about notice and, can you, when you invoke arbitration, making sure the other side has notice that you're proceeding in that way. But, probably the most common challenge to an arbitration award is that the arbitrator exceeded their powers. And, we draw some support from DAIIE versus Gavin, 416 Mich 407, 1982 case. There, the Michigan Supreme Court said that arbitrators can fairly said to be exceeding their power whenever they act beyond the material terms of the contract from which they primarily draw their authority, or in contravention of controlling principles of law. So if you have an arbitrator who, has been, that they've been invoked or brought on board to resolve a very discrete issue, and they suddenly expand their authority and start making rulings that are a little beyond what the parties agreed to, that can be a basis to seek to set aside the entire award.
Liz, isn't that kind of that whole string of case law the foundation for attorneys saying we didn't agree to let the arbitrator make errors of law?
Yes.
Isn't that always the convenient argument that people that don't like their award always say, well, I never agreed that the arbitrator could get the law wrong.
Right. Well, those, unfortunately, I mean, there may be two points of view about what the prevailing law is, but that in contravention of controlling principles of law language is not going to be simply we dispute what the law is. It needs to be something that's, very clearly well beyond the law. I try to think about something that would be an outrageous example, and of course nothing's coming to mind specifically, but it's not going to be simply we think you got it wrong. That's not going to be enough. You mentioned also under the Michigan Uniform Arbitration Act, sort of those two different time periods. That's for whether if you've already filed a complaint, if you had to file a complaint to get the arbitration agreement enforced, then if you're operating under that particular rule because you have common law arbitration, you have 91 days after the date of the award to file a motion to vacate, modify, or correct. But if there's not already a pending action, then a complaint must be filed no later than 21 days after the arbitration award. So it kind of adjusts that time frame a little bit from under the Michigan Uniform Arbitration Act. So just be mindful, if you're operating under common law arbitration and not the Uniform Act, your timing will be a little bit different. The FAA, again, the process is substantially the same, but the timing is again different. It's much more generous. An application for confirmation of the award must be filed within 1 year of the award, and motions to vacate or amend an award under the FAA are subject to a 3-month limitation period. So again, substantially, they're very similar in terms of the procedure. What's different is timing, and so make sure once you get your award, which timing you're going to fall under if you need to do anything to either enforce it or to modify it in some way. Excuse me.
And what do we do if we disagree with the court's ruling on whether to vacate or modify our arbitration award?
Well, there are appellate options. So under the Uniform Act, Michigan's Uniform Act, an appeal to the Court of Appeals may be taken from an order denying a motion to compel, an order granting a motion to stay arbitration, an order confirming or denying an award, an order modifying or correcting an award, an order vacating award without directing a rehearing. So if the court just says, I'm vacating this award and I'm not sending you back to the arbitrator to get it somehow fixed, you can appeal that. And then also anything that's considered a final judgment under the act. And so if your award is simply, you know, confirmed, that's a final judgment. You will have an appeal by right to the Court of Appeals. However, their particular review it's sort of a multi-layered standard of review. So review of the circuit court's decision to affirm or vacate an award is de novo, but it doesn't mean they're going to look at it with fresh eyes. It's a review of whether the circuit court complied with its limited review role. So it's, you know, it's de novo in terms of, did the circuit court do the right thing in its very limited ability to disturb an arbitration award. To merit vacation of an arbitration award, an error of law must be evident on the face of the award and so egregious that it materially affects the outcome of the arbitration. The case site for that concept, Hope Jackson versus Washington. That's at 311 Mishap 602. It's a 2015 case. An error of law must plainly demonstrate a disregard of principles fundamental to a fair resolution of the dispute or generate a legally unsustainable result, indicating that the erroneous legal conclusion cannot be said to be within the parties' agreement to arbitrate or the arbitrator's authority. A reviewing court may not review an arbitrator's factual findings or a decision on the merits, absent some sort of error of law that just falls within that prior description of being evident and on the face of the award. Excuse me. Circuit court cannot second guess the decision of an arbitrator if it's supported by evidence. There's an unpublished opinion that kind of gives us a bit of a discussion about what that's like. Michigan Department of State Police versus Michigan State Police Troopers Association. That's a docket number 363241, December 28, 2023. In that case, a police officer was fired after several co-workers accused her of sexual assault. And that at arbitration, it was found that the police officer's termination was too severe. And the arbitrator ordered the police officer to be reinstatement and her punishment be reduced to an unpaid suspension. The Michigan State Police argued that the arbitrator exceeded her scope of authority by setting aside the police department's decision to terminate the police officer's employment. And the trial court ultimately vacated the arbitrator's award. The Court of Appeals reversed and remanded the case for entry of an order enforcing the arbitrator's award, stating that the arbitrator is given the power to determine whether the employee was discharged without just cause. So the trial court essentially overstepped its bounds, and the Court of Appeals said, you overstepped your bounds, sending it back for enforcement of that original order. So that's, you know, that's a case that if you find yourself kind of, how do I articulate this standard of review at the higher level, look at that case. It can kind of give you a walkthrough.
Liz, we've kind of talked about the contractual origins and basis for arbitration. Can the parties contract to give appellate rights above or different from the act? Can you say if X happens, then we're going to allow this to be reviewed by the Court of Appeals or the circuit court, you know, de novo, or do they have any ability to do that?
I will be honest with you. I did some research to see if I could find some cases that said that, you know, an arbitration agreement can expand the scope of circuit court review. And I couldn't find anything one way or the other. It doesn't mean it's not out there. Considering that the goal of arbitration is to enforce the parties' agreement to arbitrate, it seems to me that they could. it seems to me that that would be enforceable. I mean, I think there are some good arguments to make that, these parties reached an agreement to arbitrate. They also reached an agreement to have certain parameters set on that award and the ability to seek appellate review. So it would be interesting to see if a court would say, no, we're going to enforce the arbitration agreement, but we're not going to enforce that aspect of it that allows for de novo review. But like I said, I haven't seen any specific cases that address that one way or the other. Now, if we're operating under the FAA, the right to appeal is pretty similarly limited. You can appeal to the circuit courts of appeal from an order refusing a stay, denying a petition to enforce, denying an application to compel, or confirming or denying confirmation of an award or modifying it in some way. Appellate review on the federal side is again de novo, but again limited to the very deferential standard that is imposed by the federal district courts and whether the arbitrator has exceeded his powers. So that that process, that appellate process, is one that is just, as we said, very limited. The goal again being to afford the parties their choice, which was to go to arbitration and to let an arbitrator decide, and having an appellate court jump in and a circuit court jump in and engage in sort of a very fulsome de novo review really just defeats that purpose. I wonder if there are any, I'm not sure if I mentioned at the outset, but if anyone has any questions, they can drop them in the chat or use the Q&A function, either one. But, just kind of going back bigger picture, Ryan, what's your experience with the ability to get third-party discovery in the context of arbitration?
If it's not voluntary, it's very difficult.
Okay.
Especially, what's that?
I was saying that's pretty much without regard to whether
it's AAA, Michigan Uniform Arbitration Act, or otherwise. An agreement to arbitrate is generally restricting third-party discovery pretty aggressively, not to say that it can't happen. And ultimately, in cases that are that large that you're trying to get into all of this third-party discovery, likely those parties are not in the same state, which creates additional problems in the subpoena power of the arbitrator. Just know that going into the arbitration process, and also when you're drafting these documents related to arbitration, if there's a dispute that arises, you could try and enhance the arbitrator's power. But if I'm receiving that subpoena and I represent the third party, I'm probably not going to be persuaded by some agreement between two parties that I'm not a party to the contract.
Right. And I think another thing too to think about is the costs of arbitration. I always see in cases where they'll talk about arbitration being a way to keep costs down, and I think I don't know who ever went into arbitration thinking they were keeping costs down, because I have never seen that bear fruit. Filing fees, particularly if it's a high value dispute, are typically on a sliding scale. If you're dealing with the AAA on a construction dispute, for example, or a consumer dispute even, the filing fees alone are several $1,000s. And then you are paying for the arbitrator's time. And if you have a panel of 3, as is required by certain AAA rules, or as may be provided for in your arbitration agreement, you're paying for all of their time, plus you're paying for the attorney's time. And
the other thing that's always fun too, like you mentioned, the notice, and if the other party doesn't appear or participate, then the party that filed the arbitration demand is required to pay the fee of both sides. And then that ultimately gets added to any award potentially. But whether it's AAA or JAMS, they're going to get their money before they do anything. So in those situations where the other party doesn't appear, generally what happens is the party that brings the arbitration ends up paying both sides.
Right. Yeah. No, I've definitely been in that situation where I'm telling a client, yeah, I know you just paid $4,000 for the filing fee for your half, but the other side's not paying, and we're not getting an arbitrator appointed until you agree to pay. Yes, I can ask for that to be put back into the ultimate award, but if they're not paying now, what's the likelihood that you're going to get anything out of them months later? And so sometimes just thinking through that, cost benefit analysis at the outset, it is definitely worth it. What's your experience with default judgments in the arbitration setting? I know it's a
Very
little bit
difficult.
unique.
Yeah, it's very difficult. They do have the notice concerns as to why people didn't necessarily appear, but they also have a vested interest in doing some work at their hourly rate, which is also why I view summary judgment as being very difficult in arbitration matters. That's probably maybe a bit of a cynical view on things, but ultimately the arbitrators want to decide the case on the merits at a merits hearing. So default judgment, summary disposition are both very difficult in the arbitration setting, at least in my experience. And so the other thing too is I've had some arbitrations where you don't just file your motion, you have to send a letter to the panel telling them why you want to file a motion. And then they will decide whether you're allowed to file your motion. So some of them can actually be more time consuming than if you were in the court because you just file your motion. Whereas in some arbitration proceedings, there's kind of an additional gatekeeping mechanism that the arbitrators can say, I don't think that is worthy of our time. We're not going to let you file a motion on that.
Mhm. And you ultimately have to do the research, and your letter in support has to, you know, give some meritorious argument about why you should be allowed to do it. And so your client is incurring all that cost. And theoretically, if you're not allowed to file the motion, you'll use that later in a trial brief or something along those lines, or a hearing, briefing that is done for your arbitrators. But it's not as straightforward as I suppose parties would often like to think. Um, Something I've also found too with arbitration is that the timing and the scheduling can start to become onerous. If you are dealing with three a three arbitrator panel, so you've got three practicing attorneys generally, who are serving as your panel. You've got the two attorneys who represent the parties. That's assuming you only have two parties. You've got the parties' schedules, and you're trying to coordinate all of that to get, hearings scheduled, to get um, productions done, all the things that happen. When we're in circuit court, judge just sends you an order and says, this is what you do, and this is when you do it by. My experience is that in arbitration, they want to try to, conduct it more according to when the parties can be available and will be available. And if you've got someone on the other side who's playing games and is, not going to be available for the next 6 months, that can create problems. And so I think that's something that parties don't really think about until it's happening in a case. That there's going to be a little bit of just back and forth, just trying to get us in front of someone, let alone what happens once we get there.
Yeah, I think one other thing to be aware of when it relates to arbitration, if you're the party that wants to arbitrate and the other side goes and files their action in circuit court or district court, whatever it may be, if you participate in the litigation, there's going to be an argument that you've waived your ability to arbitrate. So be mindful of that in preparing an answer and consider a motion for summary disposition in Michigan under C7 because of an agreement to arbitrate. Should you not do that, you might lose your opportunity to do that. So something to be cognizant of, not only if you're the party that is trying to file the arbitration demand, but also if the other party files a litigation in court first, be strategic in how you respond to that, so you don't waive any rights you want to ultimately enforce.
Yeah, absolutely, absolutely. I think that kind of brings us to the end of the issues that we wanted to talk through today. Um, we'll wait here a second or two and see if anyone has any questions, anything they wanted to discuss more particularly. But we would like to thank everyone's
Yeah,
attention.
definitely. Thank you for coming.
Absolutely. And then what we typically do is we will send out a link to the recording. So if there's anything you wanted to look back at, um, and then we'll also send a little a handout of takeaways. And so that kind of is a bit of a summary of what we discussed with some references and things of that nature. Um, so hearing no questions, I think we'll call the seminar closed, and thank you, Ryan, for appearing. I appreciate it very much.
Thank you
Um,
for having me.
and thank you to our attendees. We appreciate your time and your attention.
Thank you.
Thanks. Bye bye.